Life Unrehearsed, brought to you by Lianas Senior Transition Support, specialists in downsizing and seniors residences.
And welcome back to Life Unrehearsed. Matt De Riggi here, specializing in life transitions, downsizing in the senior living industry.
And I'm Corrie Sirota, clinical social worker and author of Someone Died, Now What?
Corrie, we've been so blessed. Some great feedback on our revised format that we do now. We've done this for a few weeks now in the second half of each show, where it's a segment called Helping Moms and Dads. And we're having some interesting, knowledgeable guests covering a vast array of topics to help families, sandwich generation, their moms and dads with the challenges of the aging process.
And I'm really enjoying it, and I think we're learning so much by this. So, I'm glad our listeners are enjoying it, because we are. So that's it. And in keeping with that, Matt, what do we have coming up on the second half of the show?
We wanted to bring up the topic of legal affairs, getting legal affairs in order as we age, because things change. You're in your 30s and 40s, and you have certain things to take care of. And as we age, you start to get a lot of questions, and things happen not only to yourselves. Life moves on, and you're worried about your folks, you're worried about your grandparents, you're worried about yourselves. So we thought no better time to bring in our notary supreme, Nadia De Riggi. Nadia is a wonderful notary that's helped us in the past, and she's going to help us sort out some complicated matters when it comes to getting our legal affairs in order as we age. Nadia, welcome back to Life Unrehearsed.
Thank you. Hi, guys.
Hey, so glad you're on the phone with us. COVID, the pandemic, has really opened up a lot of eyes. It's made people put things in perspective. And of course, we've had the discussion, certainly in my world, in dealing with seniors and their kids, the adult children, the topic of wills are coming up more and more. And so let's back up, Nadia, and if you could explain the difference between a will, and I also hear the term living will.
Yes, so I hear those terms a lot too, and I think it's an important topic to discuss. So a will, as many of your listeners may already know, allows us to make decisions ahead of time regarding our property after we die. And the biggest difference between that and a living will is just that it's the timing in which it's going to be used, and the scope or the content. So a will is going to talk about property and how it's divided and who's going to be in charge of that after we're no longer here. But a living will is going to talk more about medical care and, what happens if we're in a position where we can't express ourselves, which medical treatments do we accept, which medical treatments do we absolutely not want. So it's a document that will allow us to express those wishes in advance.
Very clear. Thank you for that, because I think I know, and then I forget, and then I know, and then you remind me. So thank you. Just curious, what percentage of people actually have a will in place?
Okay, so I looked into this for you, and the latest numbers that I was able to find were only pre-pandemic numbers, and I have a feeling that this has changed in the last year and a half, just based on my own experience, but I was able to find that 51% of Canadians actually don't have a will in place. Again, that's pre-pandemic, so I do suspect that the next survey will show maybe a decrease in that. But for now, 51%, which is quite a lot.
It's amazing, actually, to hear that number. And I've heard that number in the past. And let's say it has improved and it's increased maybe only 45%, a big jump.
Right.
Still, almost half of Canadians don't have a will, and it's mind-boggling. And so maybe we can motivate a few people that are sitting on the fence and not doing it. Explain to us, Nadia, what happens if you don't have a will?
So if you don't have a will, it's essentially the law, or here in Quebec, it's going to be the civil code that's going to determine who your heirs are. And not only that, but also what percentage they inherit in. So, for example, if you're in a common law relationship, regardless of how long you've been in that relationship, your common law spouse will not inherit from you, ever. Similarly, if you're married, your spouse doesn't necessarily inherit everything. If you are separated, so I meet a lot of couples who are actually separated physically but not divorced, your spouse is actually still considered an heir under the Civil Code. And, your kids could end up being co-owners of your property with your spouse, even if they're minors. So there are all these sort of scenarios or things that can happen that we don't necessarily plan for. Hence the importance of meeting with a notary and writing down a will and writing exactly what it is that you want to have happen should you pass away.
That's the voice of Nadia De Riggi. She's a notary, and she's helping us understand legal documents and why it's so important to have them in order. So there's a term that is thrown out there that people don't necessarily understand, and that's probate. What does probate mean?
So probate actually means to have something recognized as official. So when we talk about probate, we're talking about things like handwritten wills or wills that are written with witnesses. These are documents that are recognized under our civil code, but in order for them to be enacted or used, we have to bring them before a court of law to be recognized as official. So a judge is going to verify the content of the document, the form of the document. They may even check the handwriting of the person who's written the document. We're going to notify family members that the document exists. So all of these things are going to be checked. So to probate the document means just that, to have it verified by a court of law.
And from what I understand, outside of you hear that more outside of Quebec, right? So if you've got a notarized will in Quebec, from what I understand, probate it really doesn't. It's not taken into account because it's been notarized. Is that my understanding?
So in Quebec, there's 3 recognized forms of wills, and we can have a whole show on this.
Yeah.
A notarial will, just to recap, notarial will, that's it, does not have to be probated, but you can have a handwritten will, or what we call a holographic will, or you can have a will that's written with witnesses. So this is often a will that will be drawn up by an attorney. And those two last forms have to be probated or brought before the court. We sometimes say homologation, so her homologation.
Okay, can I ask a silly question, though? Is it better to have even that than nothing?
Yes, the answer is yes.
Okay, thank you. So do something, folks. Do something.
Absolutely. And
anything, but do something.
To avoid the whole probate process as well, just reach out to a notary and just get it done. We're talking with Nadia De Riggi, a notary, helping us navigate some of these legal questions. And I'd like to switch gears a little bit, Nadia, and talk about some of discussions that you have with your clients about end-of-life directives that families need to really bring out there.
So I think this goes back to the definition of a living will. If ever you find yourself in a situation where you're not able to talk to your doctor to express what your wishes are regarding medical treatments, these are the things that you want to talk about with your family or your loved ones and those family members that will be there. So things like whether or not you want to be kept on a respirator, or if you're suffering from a terminal illness, what measures or how far do you want those measures to go? Do you want palliative care or not? It's a good idea also, I think, to get an explanation of these treatments, not from your notary, but from your physician.
Right.
They'll be able to explain a little bit in depth what the treatment options are and what the possible side effects are, and it'll allow you to make a clear decision.
I think that it's the discussions that we have to have. And speaking of discussions, last month we talked about the power of attorney and protective mandates on our show, the difference of the two. And we've had a lot of feedback, but the truth is people constantly forget. So we're going to review that with you so that people are all crystal clear about that.
Life Unrehearsed, brought to you by Lianas Senior Transition Support, specialists in downsizing and seniors residences.
Welcome back to Life Unrehearsed. My name is Matt Del Vecchio, along with Corrie Sirota, and we're talking to notary Nadia De Riggi, and she's helping us get our legal documents in order, especially as we age, Nadia. we brought the topic up of power of attorney and protection mandate last month on a show, and it obviously resonated with a lot of people. We got tremendous feedback, and we felt it would be worthwhile to address this again. And I see this time and time again in working with families and the children, and I hear, I got power of attorney, we're good. And the reality is the power of attorney is good, but people don't know enough about a protection mandate. So we're going to put you on the spot here, Nadia. Let's start with power of attorney, and then we're going to ask you the difference between that and protection mandate.
Okay, so I was, the main differences between the two are when is the document being used, how is it being used, and the scope of the responsibilities outlined in the document. So with the power of attorney, you can use the document right away. So you're appointing someone to do specific things for you right away. You're authorizing them to take the document and use it on your behalf. And it pertains only to your property. So, we think here of things like banking power of attorney, who's making your deposits, signing your checks, paying your bills, picking up your parcels from Canada Post, filing your income taxes. So the list can be general, or it can be specific, but it will pertain only to property. The mandate is a little bit different in that it cannot be used right away. In order for the protection mandate to be used, you have to be declared incapacitated by a court of law. This procedure is called homologation. And it's going to be used only once the homologation proceedings have been taken and a judgment has been rendered. In terms of the scope of responsibilities, it's a little bit different from a power of attorney in that it not only pertains to your property, but also to your healthcare decisions or your personal decisions. So things like, where are you living? Do you need to be placed in a residence? Do you need the CLSC to come to your home once, twice, 3 times a week? Who is going to make your medical appointments? Who are you authorizing to accompany you to those medical appointments, to have access to your medical files, et cetera, et cetera? So those are the 3 main differences. So again, when is the document being used? How is it being used? And what is the scope of the responsibilities that are outlined?
And just to be clear, who does one make these with? You, as a notary?
Yes. So there are 2 ways you could write these yourself. You find there are forms online, or you can come to see a notary, and we will sit down with you and look at this list of responsibilities and see what exactly you need. What are your needs? Based on your lifestyle. Do you own a company? Do you need somebody to run your company? Do you have investments? How do you want to make the document general? Do you want to make it specific? Do you want to name one person, several people? So you can do it both ways. You can write it yourself, or you can see a professional to help you.
This Notary Nadia De Riggi, and she's helping us navigate our legal documents. So I just want to expand a little bit more on homologation. We hear this term every now and then, and want to be crystal clear what it is. It's basically you are assigning someone, if you are declared incapacitated, that person can now take over some decision-making powers for you. Now, let's say I have to go through this homologation process for it to actually be enacted. And how long does that process take, and how does it happen?
So right now, I can tell you that in Montreal, it could take, several months. I can't give you an exact number. It really depends on the volume of files being processed in court at any given moment. But your first contact will be with the notary or with the physician. And what's going to happen is the notary is going to request a medical evaluation of the person concerned and a psychosocial evaluation of the person concerned by a social worker. And these evaluations will serve as the basis of our application in court. So they're going to serve to show the degree of incapacity of the person concerned, and it's really going to show that this person does in fact need legal representation.
Okay, let's take all this information and put it to concrete, and the way I learn, through examples. So I'm going to give you a scenario, probably one that you're familiar with. So let's say a couple wants to sell their house. One of the two has been diagnosed with dementia for several years now. Can they sell the house with only having power of attorney in place? And I guess, what is the importance in this case, and or not, of the protection mandate being homologated?
So I do see this often, especially with the real estate market being so hot right now. We get files with couples selling their home, and then, I open the file and I learn that the husband has been suffering from an illness for many years. So to answer your question, power of attorney cannot be used in this case. Power of attorney can only be used if the person is able to understand what's going on and they're able to give instructions. So we're going to look at the document and see, is there a protection mandate here attached to the power of attorney? And if there is, we're going to want to homologate that. So we're going to have this person assessed by their doctor and by a social worker to attest to the degree of incapacity. And we're going to notify this person that we are having their mandate homologated. We're also going to notify all of the interested family members. And we're going to make sure that the mandatory that's appointed in the document is still willing to act as mandatory. So we want to make sure that everything is lined up so that we have a favorable judgment, which will allow us then to sell the house.
So just to be clear, if there was no protection mandate, what would happen?
Okay, that's a whole other
show
other proceeding. Yeah, also. But if in that case, any interested family member could step forward to act as this person's curator. We would still have to go to court. We would still go through the evaluations. There would be an extra step of having a family council meeting to make sure that everybody's on board and everybody agrees to having this person act as curator. And the big difference is that the curator, that is the private curator that is appointed, and the family council will have to render an account of their administration annually to the public curator of Quebec.
The notary Nadia De Riggi, just trying to help us understand the differences between power of attorney and protection mandates. Please, I've seen this too many times when they want to sell a property and there is one of the couple that may be having some cognitive challenges and may be considered incapacitated, and they cannot sell that property unless that homologation process is in place. It's very simple. Just put a protection mandate in place. It could be done through a notary, and the directions can be there for you. You still have to go through the homologation process. Like Nadia said, it's about 3 to 4 months these days. It doesn't happen in a matter of a couple of weeks, so it's better to be prepared in advance. Nadia, we need to wrap up. We could have you on and talk about so many different subjects, but we want to thank you, and we do appreciate your words of advice. Can you let us know how people can reach you?
Absolutely. So people can reach me on our website. It's lamarderiggi.com, or by phone at 514-484-2788.
All right. This is notary Nadia De Riggi from Lamar De Riggi. Thanks so much. All right, Corrie, what do we have coming up on next week?
Next week, Claire Webster and Dr. Gauthier will talk about the recently launched World Alzheimer's Report and new educational guide for people living with dementia. These are spectacular documents that are worldwide, and I can't wait to talk to them about them. And given that the holidays are coming up and families are going to be gathering, it might be an ideal time to have some of the important conversations we just reviewed on today's show. So thankfully, Matt Del Vecchio is going to be here to offer some helpful tips about how to do just that with your folks.
All right. Well, thank you for tuning in to Life Unrehearsed. And as a reminder, for all your inquiries or assistance with retirement homes, seniors residences, home care, or downsizing, it'd be my pleasure to help. Call me at Lianas Senior Transition Support, 514-622-8074. We want to thank our technical producer, Jimmy G. Great job, Jimmy. And you can listen to Life Unrehearsed here on CJAD 800 every Saturday at 3 p.m. And don't forget to change the clocks tonight before going to bed.
Are you considering downsizing your home? It's an overwhelming process. Where do you begin? Hi, I'm Stephanie Cadu, residential real estate broker with Royal Lepage Village. I understand the stress and anxiety seniors experience. Taking the important step of selling a family home is overwhelming. That's why I'm supported by a team of professionals in downsizing, home repairs, and staging. Please visit my website at movingsenior.ca or call 514-885-3524.